All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you, everyone. So we will continue with the agenda items. I turn to the issue of the update on the confidentiality protocol and related issues of contacts with witnesses and victims. There's two issues here. One is the discussions on the protocol and
I apologize for interrupting,
sorry,
but
you're right,
Mr.
Mr.
Hassan's not here.
Al Hassan.
I apologize.
My apologies. My apologies, we should have waited. I know Mr. Al Hassan is now in the courtroom with us. So we're turning to item 5, update on the confidentiality protocol and related issues. There are two discrete issues. One is the general discussions ongoing about the confidentiality protocol and related issues. And also there is a very specific proposal from the LRV. I'd like to deal with those issues separately. To begin with, I would like to shortcut the issue on the discussions relating to the confidentiality and dual status protocols. This is an urgent and important matter. I don't think the most efficient way to deal with it is to have the chamber reviewing comments and track changes on different documents. I am hopeful and I'm confident that the prosecution and the defense, I understand there were discussions again yesterday, or at least that's what was mentioned by the prosecution. I'm hopeful that you can come to agreement, or at the very least come with a couple of discrete issues that remain to be resolved. So rather than hearing any submissions today, rather than the chamber engaging at this stage, I would encourage you to do this and then to come to the chamber if you have remaining issues in one document, please, that identifies very clearly what the two positions are, what the issue is, and then the chamber can adjudicate on that. But I think that's a much more efficient way to proceed with the general discussions related to those protocols. So if we could agree to proceed on that basis, I would appreciate if this is dealt with urgently. And it would be great if we could have something before us if there are any issues by the end of next week. I know that this is an urgent matter that affects investigation, so I encourage you to do that as well and as quickly as possible. I'm moving to the issue raised by the legal representative of victims. You have made a proposal for what I understand to be an additional protocol in your email. I don't know if you wish to add anything to that submission today in the status conference, or if you wish to simply rest with the particulars. But please feel free to expand upon your proposal.
Oui, je vous remercie.
I'd like to thank you, Your Honour. I think that we're going to add something in our written submissions, quite simply because we can see that in the discussions that are underway, the discussions are much more about witnesses with dual status. And in the meantime, the victims who participate in a general way are spoken less of. As such, we would like to refer to the protocol which was signed in the Katanga case, where the chamber largely took into account the participation, or at least contacts, with victims who participated in a general way, and regulated the contact that the parties had in such cases. But here, What I also wanted to raise was a problem which I had noted having reviewed the protocol in Katanga. The proceedings are obviously a bit different. The parties do not receive the application form for victims, so it's difficult in advance for the defense or for the prosecution to know if the person is a victim who's participating or not. As such, that raises a problem. All the more so because the identity of the victim at that stage is protected. So there is no communication of the identity in the decision, or before the decision confirming the charges. The pretrial chamber had recognized the quality of victims participating for more than 800 applicants, but those are just reference numbers that were communicated to the parties, so it's difficult for the parties at this stage to be able to identify if the person who they approach is a participating victim or not. And as such, you have to refer to the legal representatives of victims and organize matters such that we can take up contact with that victim and so on. And as such, what we are trying to do is to come back to the chamber in a written submission in order to try to raise all these different aspects and, of course, to propose solutions or potential solutions for participation of victims. But where it concerns dual status victim witnesses, as it were, discussions are underway, and I think that we will be able to come to an agreement or find a solution together. That's what I wish to add with regard to that issue.
Well, merci beaucoup pour
Thank you very much for your
I agree.
submission.
I think that sounds like a very good way forward. So I trust that the parties, in the course of agreeing as much as they can on the confidentiality and contact protocol, will also share that with the legal representatives for victims, and then knowing what that is and how that is framed, then, as you've indicated, you could come forward with submissions regarding anything additional that you think might be needed. But I do appreciate that you've noted the distinction between the cases, the precedent cases, and this case. And I think there may be some difficulties in terms of applying a similar protocol, but certainly the Chamber will welcome any, particularly any submissions with solutions that would be very, very well received. So if we can proceed on that basis, first issue and most important is to reach agreement as far as possible on the confidentiality and contact protocol, and then we'll proceed from there with any possible additions or different approaches to be taken with respect to dual status. So I think that, in short order, can address that particular issue on the agenda. If I could then move now to the clarifications related to the prosecution's provisional list of witnesses. I believe the defense raised an issue regarding the status of individuals who were not included on the prosecution's list. Ms. Taylor, did you want to add to your submissions on this point?
Thank you very much, Your Honour, although I do note that this is linked to the confidentiality and contact protocol, because essentially this is why we underscored the need to resolve these issues on an urgent basis. It's our position that if an individual is not on the provisional list of witness, then they fall outside the definition of a witness for the purposes of the contact protocol, and we should therefore have the right to initiate contact with them. So I don't know if this is an issue which we can resolve today or whether we should defer it to the resolution of the contact protocol itself.
Thank you for that. I mean, there could be, as I understood, your issue might be about individuals who are not on the list at this time, and whether or not whatever the contact protocol ultimately says is applicable. I understood that might be an issue which we could try and discuss. I don't know if the prosecution has any comments on this point.
Oui, Madame la Juge. Ma collègue Diane.
Yes, Your Honour. My colleague Diane Looping is going to give some explanations in this regard. The fact was that the chamber, pre-trial chamber, had indeed indicated that the witnesses approached by the prosecutor, whether or not on the list of witnesses for the confirmation, it was the protocol that applied in that case, and that was good because it was quite a premature stage at that point where witness 77 could be on the list, and there was no need to call all witnesses for the confirmation of charges hearing. Now, we had a meeting yesterday with the defence, and I think that we are quite close on these issues, and perhaps there are 4 witnesses where there are certain issues about, but I think that positions aren't very far from each other. I would give the floor to my colleague Diane Looping, who will speak further in this regard.
Thank you, Your Honour. Just briefly, because as my colleague Mr Duterte indicated, we did have a fruitful discussion yesterday, and we hope to have a fruitful discussion this afternoon. We will have to see, obviously, how that develops. There are 2 discrete points, though, that we do think that it would be worthwhile to raise with you at this juncture, even before those discussions, because it does relate to interpretation of the contacts protocol, and it is unlikely that the discussions will resolve or change the positions of the parties on this. Just in terms of the issue that the defence raises, that it considers that any individual who is not on the current provisional list of witnesses is not a witness for the purposes of the contacts protocol. Well, with respect to Your Honour, the prosecution disagrees, and I'd like to explain why. The prosecution considers that it's not only those who are stated to be on its provisional list of contacts who are covered under the contacts protocol, but instead any witness whom the prosecution clearly communicates to the defence that it intends to use as a witness, and from the moment that this is clearly communicated. And this is because of the definition, Your Honour, of a witness under the contacts protocol, and I refer to Article 4F, that a witness is defined as an individual where the intention of the party to call the witness or use the statement has been clearly communicated to the opposing party. So in our submission, Your Honour, the prosecution may give this notice to the defence of the identities of such witnesses, effectively on a rolling basis until the final list of witnesses is filed as ordered on 14 April. And now at that point, obviously, all the witnesses, including additional witnesses on the final list, are subject to the contacts protocol. But even before then, as soon as the prosecution clearly communicates to the defence that a person is a prosecution witness whom it intends to call to testify or rely on their statement, then that person is a witness for the purposes of the protocol. And we just wish to bring to your attention, Your Honour, that the prosecution did yesterday at our meeting on the 17th of February communicate to the defence the witness codes of 4 specific, currently characterised as Rule 77 witnesses, that it does intend to call as witnesses. And I would like to inform you of the codes of these witnesses. That is P0107, P0555, P0204, and P0647. Now, this is our current intention. Obviously, we will come to a final decision when we file our final list, but this is our current intention, Your Honour. So in our submission, any additional witnesses that the prosecution does provide a communication of as being individuals that we intend to use as a witness, even if they don't appear on the provisional list of witnesses, are covered as soon as we communicate that status to the defence. Now, we would agree, just to be clear, that we consider that the defence may, at this juncture, approach other Rule 77 witnesses whom the prosecution is not seeking to include as potential witnesses to testify. And we further agree that this contact with other Rule 77 witnesses would not constitute a violation of the contacts protocol. But we would note for the record that we would assume that in compliance with Rule 81.4 of the Rules of Procedure and Evidence, Article 68 of the statute, and the clear terms of the confidentiality protocol, that the fact that any of these individuals have interacted with the prosecution should not be revealed to third parties to ensure their security and protection as persons at risk due to the activities of the court. And I refer in particular to paragraph 6 and 9 of the confidentiality protocol. The second issue, Your Honour, that we would like to raise at this point relates to the issue of the implementation of the existing contacts protocol. And this is not an issue that is a matter for discussion as such in terms of the language of the contacts protocol, which is why we are raising it before Your Honour now. Now, to be clear, the prosecution is not suggesting that there has been any deliberate violation of the protocol by the defence at this stage. However, we do consider that it's important to raise our concerns with the Chamber regarding certain instances where there have been an apparent at least violation of the protocol, and where in our submission these situations should and could have been avoided. I would like to raise one specific example, but to do so I would ask of the, with your leave, Your Honour, if we could briefly go into private session. It will be brief, just for the purposes of providing this example.
Yes, if we can go into private session, please.
We are back in open session, Madam President.
Council, you may continue, but I would like to try and keep the issues confined to general issues as identified in the agenda. So I'll let you finish your point, but if you can come to a conclusion on the specifics quickly, that would be good.
Thank you, Your Honour. Our point in relation to this example is simply that in this case, even if the defence does not share names of all of its witnesses on the prosecution's list with its resource persons, that they do need to be asked in our submission. They could be asked to revert to headquarters before they contact specific persons so that counsel can then confirm whether or not that contact can proceed or not. And this can happen without specifying reasons why they should or should not proceed. We do not consider that it's an excuse or that there's no violation of the protocol if a member of the team is not informed that a person is a prosecution witness. Otherwise, our concern is that there may be further instances of inadvertent contacts with prosecution witnesses. Now, we think that there should be a workable mechanism to avoid this, balancing the interests of the defense needs of investigation and the prosecution witnesses' need for protection. And we think that this proposal of a system whereby resource person or intermediary in the field reverts back with a proposed name achieves that balance. Now, in terms of the obligations of those resource persons, I would just briefly refer, Your Honour, to paragraph 5 of the protocol, the fact that all the obligations that are incumbent on them as well, and paragraph 27, that the obligations of contacts kick in and arise as soon as we inform the opposing party of the identities of our witnesses. That was all we wanted to raise at this point, Your Honour.
Thank you, Counsel. Ms. Taylor, I can give you the floor but I would make it clear I'm not going to decide on anything today with respect to the operation of the protocol or these specific issues of dispute. They've now been highlighted. I am sure on the second issue that you've heard the points raised by the prosecution, and I accept entirely that this is not any kind of deliberate action. So, as I say, I will give you the floor, but bear in mind that these are issues that can be resolved in due course. I'm encouraged to hear about the continuing discussions, and I think all of these issues can easily be resolved amongst the parties through reasonable discussions, and hopefully the Chamber will not have to intervene. But if we do, we'll do that at a later stage. But with that caveat, you have the floor, Ms. Taylor.
Thank you very much. And may I start in private session just briefly to address the issue? I will be very brief, but I have an abundance of caution.
If we could go to private session briefly, please.
We are back in open session, Madam President.
The second issue concerns the definition of a witness, and we did indeed have constructive discussions with the prosecution yesterday, but they were framed in a somewhat different manner. During these discussions, the prosecution, at our request, indicated that there were 4 individuals who they might call as a witness. They didn't know if they wanted to call them as a witness yet. So under the terms of the contact protocol, this falls outside the definition. This is not a clear intention to call this person as a witness. Now, of these 4 individuals, one of them's statement was disclosed as PEXO, exculpatory. We don't have Arabic translations for these individuals. They haven't been put in the Rule 76 bracket. So we would submit that if the prosecution has formulated a clear intention to call someone as a witness, firstly, they have to move them to the Rule 76 bracket. They need to comply with their translation obligations, and they need to convey this to us in means which aren't equivocal. And that can be done, for example, through an amendment to the provisional list of witnesses. That's an easy solution. And what we're asking for here is entirely consistent with the case law of this court. In Bagbo, in Ongwen, the definition of a witness has been litigated ad infinitum. And in all those cases, it was the prosecution insisting that it had to be defined in a narrow manner, because otherwise it could inveigle the parties in needless discussions concerning irrelevant persons. And indeed, at the very beginning of this case, it was the prosecution who requested the pretrial chamber to adopt the definition of a witness as formulated in the Bagbo case. And when asked to explain why they had done so, they said, because otherwise it is not clear for the investigating or opposing party whether an individual is a witness of a calling party. So that was the prosecution's own position in this case. And we would submit that that's a fair position, and it's consistent with the right to a fair and speedy trial. These individuals can't stay in limbo while the prosecution sits on its heels and makes up its mind whether to call them as a witness. We need to interview prospective witnesses sufficiently in advance of the commencement of the trial so we can formulate a coherent strategy. Now, if the prosecution has already decided that those 4 persons it tends to call them, then today it can amend its list. It can put those 4 individuals on its list, and from henceforth we will treat them as Rule 76 witnesses. We will also invite the chamber to adopt adverse inferences or appropriate measures if they're taken off the list. But what they can't do is put them in limbo and have this very equivocal status where we simply don't know if they will or will not be a witness. So that's our position, and we believe it's entirely consistent with the case law of this court. And if it were not to be adopted as concerns prosecution witnesses, then obviously the reciprocal would apply to the defence. That is, the prosecution could not contact individuals irrespective as to whether we put them on a list. So here we need a clear reciprocal obligation and position to guide the trial proceedings. Thank you.
Thank you very much. Well, I don't think we need to discuss this point any further. I believe the parties are quite close together on these issues. A little more discussion. I'm quite satisfied that you can come to an agreement. I don't see any differences in great principle. I think it's a matter of how things are communicated. It is, I do point to the prosecution, what the defense mentioned was something I would mention too. It is, of course, you have a final date for your final list, but you can at any time provide an updated list of witnesses, which would bring some clarity. I'm not saying whether that's the only means of communicating. I'm not deciding on those issues. I would just invite you to continue your discussions, and hopefully this will not be an issue at all that requires the intervention of the chamber, and that we can proceed accordingly with an agreed protocol in very short order. So I encourage you to continue the discussions. I think all the points have been made on the record, and so I would simply want to conclude that agenda item at this point.
Thank you, Your Honour. I won't make any additional submissions on this agenda item, except just to correct the record. I had indeed stated that the resource person was not aware, and I have been informed by my colleague that that was incorrectly transcribed. So I am putting that on the record as requested by defence. That is indeed what I had stated. Thank you.
Thank you very much. We can move now then to the question of prosecution disclosure obligations, related issues and updates. I would like to hear from the prosecution first with a general update on ongoing disclosure and how that's proceeding. Thank you.
Je vous remercie, Madame la Juge. Je récupère le...
Your Honour, I'm just finding the document.
J'en aurai pour plusieurs minutes.
So I'll have a few minutes on this. Please excuse me in advance for my explanations with a number of packages, numbers, etc. But all the information is there. So since the last status conference, we've communicated between the 19th of December 2019 and the 17th of February yesterday, 17th of February 2020, 9 batches of incriminating evidence. So the pre-trial batches, INCRIM 44 to 52, 5 batches of evidence under Rule 77, i.e. the pre-trial batches from Rule 77, numbers 33 to 37, 4 update batches and lifting and update packages of metadata, and I won't give you all the different numbers for these packages. 1 batch for reclassification of incriminating evidence. In terms of the volume, the INCRIM batches correspond to 1,936 documents and 11,887 pages. That includes large numbers of evidentiary items in which there are redactions to the identity, or in which the redactions to the identity of witnesses have been lifted. If I take, by way of example, the 13th of January batch for P0626, 58 documents, 945 pages, without redactions to the identity of the witness. But we also have communicated 77 without redactions, P65 and others. Now, the batch under Rule 77 corresponds to 624 documents and over 3,700 pages. And there too, with lots of witnesses whose identities were communicated to the defense. So P65, 77, 572, 73. So various numbers of witnesses, P0581, 583, 592, P593, and others. The other batches, that's to say, the batches on the metadata, correspond to 3,000, over 3,000 documents, 3,980 documents, and in these batches we have lifted redactions concerning the identity of witnesses in the chain of custody, but also the identity of investigators. And so we have also added, where necessary, the field related to witnesses, and we have filled that in for certain witnesses, for which we have the authorization not to do, or we got that authorization in advance from the pretrial chamber. So that's a large volume of information which was communicated with the lifting of non-standard redactions and the lifting of standard redactions. Name of the investigators, names of the interpreters, and B2 and B3 redactions as well as requested. Now, where it concerns communication of the identity of prosecution witnesses, I'm trying to give a clear view of the situation as to where we are now.
Et je me base sur
And I'm
l'annexe
basing
A
myself on Annex
au
A
FALI 572
of
qui était
the filing,
liste
which
provisoire
gave
des
the
témoins
provisional list of
telle que
witnesses
communiquée le
as
31
communicated
janvier
on the
2020.
31st of January 2020.
Cette liste comptait
Now, this list
78 témoins.
contains 68 witnesses,
Donc 78.
78 witnesses.
Sur ces 78
And among
témoins,
these 68 witnesses,
78,
among these 78 witnesses, corrects the interpreter,
l'accusation a
the
d'ores et déjà
prosecution
communiqué
had already
l'identité de
communicated
60
the
témoins à la
identity
défense.
of 60 witnesses to the
Tu vois
defense.
que c'est un travail commun avec l'interprète.
See, that's a common work with the interpreter as well. And
Donc 60
so,
témoins,
60 witnesses
dont
out
l'identité
of
est
the
d'ores et déjà connue par la
78
défense.
whose identity was already known by the defense.
Il y a en
Now,
plus 7
there
témoins
are
pour
also 7
lesquels
witnesses
l'identité
for whom
sera
the
communiquée dans les
identity
délais les plus
would be
favorables.
indicated in the earliest possible deadline, by the earliest possible deadline.
Cela comprend
Now, that
notamment
would also include
trois des témoins
no,
visés
3
dans la
witnesses
récente décision
who
de la
were referred
Chambre
to in the
de
recent
l'arrêt
decision of the
42,
Chamber on
décision
Rule.
586 que vous avez
So,
retenue.
decision 586, which you issued, Your Honour.
Donc cela fait un
So,
total de
that makes a
67
total
témoins
of
sur
67
78
witnesses among 78,
pour lesquels la
for
défense
which
aura
the defence
l'identité au plus
would
tard
have
le
the
10
identity
mars.
by the latest on the 10th of March.
Reste
That
11 témoins,
means there are
Madame la juge.
11 witnesses left.
Sur ces 11 témoins, il y
So,
en a 10
among
pour
the 11, there are
lesquels on
10
retire une requête au
for
fond de
whom
disclosure.
we are planning an application for delayed disclosure,
Et il y a
and
un
there is a
témoin
witness
qui est mentionné dans votre
mentioned
décision
in your
récente,
decision.
sur l'arrêt 42, décision 586,
That's 586,
pour laquelle la situation dépend de la mise en œuvre
where
des mesures de
it
protection.
depends on the implementation of protection measures,
On avisera
and
le moment
as
venu.
such, we will come to that at the appropriate juncture.
Si on peut le communiquer aussi, ça fait
If we
un
can
11e
also
témoin
communicate that,
pour la
that would be
delayed
the 11th witness for delayed disclosure.
Donc, pour me résumer,
Just to sum up,
aujourd'hui,
Today,
sur les listes des 78
of
témoins de la
the
liste du 31
78
janvier,
people on the list, the
La
January
défense
list, the
a
defense
60,
has 60,
aura 67
will have 67,
et
names,
de 10 à
and
11
between
témoins feront
10
l'objet
and 15 witnesses will be the subject of an application for deferred disclosure.
Donc la situation est claire,
So I think the situation is clear
ces témoins.
when it comes to these witnesses.
Je passe maintenant aux
I'll now
témoins dans les
move
catégories
to
règles
witnesses
77
in the Rule 77 category,
exonératoires.
or PEXO witnesses.
Il y a à peu près 20 noms de
There are
témoins qui ont
about
été
20
communiqués
names that have been
à la défense.
disclosed to the defense.
Certains dont j'ai mentionné les
Some
numéros précédemment,
Numbers have been given earlier.
P0 592, 93, 94.
P592, for example,
Et le reste est toujours en
93,
train d'être revu.
and the others are still being reviewed.
Et donc on fait ça dans les délais les plus rapides.
And we were doing that as quickly as possible.
Maintenant, sachant qu'il y en a qui
Now,
relèvent de la règle 42, mais c'est un point sur lequel je reviendrai.
Some of
peut-être en
these
fin
people
d'audience avec
do come
la
under
commission.
Rule 42, but this is something that we will turn to later on.
J'en passe maintenant à la communication des
Allow me
versions,
to move on to the
des
disclosure
auditions moins expurgées
of
des documents en
less
général.
redacted versions of statements.
Pour les témoins dont
Now, in the
l'identité
case
a
of
été
witnesses
donnée,
whose
récemment et qui étaient
identities were disclosed
antérieurement,
recently, who had been redacted earlier,
les déclarations sont
the
évidemment
statements
une tautologie moins expurgée,
are less redacted,
mais ça ne concerne pas
course,
simplement l'identité qui
but
est donnée,
not just the identity has been provided.
c'est aussi les
We
expurgations
have
standards
also
A4,
listed
B2, B3 qui ont
A4,
été,
B2,
levées.
B3 redactions.
Et je donne pour exemple
For example,
le témoin P582
P582,
ou P0537
P0537,
ou P0431
or
qui a été communiqué hier suite à la
431.
décision de
That particular statement was disclosed yesterday in response to your earlier instructions. correction, your ruling of last week.
Pour les témoins
Now,
dont l'identité était
In the
déjà
case of
connue,
witnesses whose identity was already known,
nous avons déjà pour
we have
partie
already
procédé à des redivulgations
carried
avec moins
out
d'expurgation.
disclosure with less redaction,
Et c'est le cas
and that
pour un
is the
certain nombre de
case for a
témoins,
number of
comme le témoin
witnesses,
P0150,
P150,
P0007,
P0007,
P0125,
P0125,
P0610,
P04, correction, P610,
P622,
P622, P623.
42, and so on. Pour les
Now, as for
éventuels nouveaux
possible
témoins,
new witnesses
qu'on mettrait sur la liste, nous
that
n'envisageons
might
pas
be
à ce
put
stade de requête
on
de
the
fin d'expurgation,
list,
donc
we
il
do
va
not we are not considering
directement.
applications for redaction purposes at this stage.
J'en passe maintenant à la
Allow me to
communication
move
des
on
traductions en
to
arabe des
the
déclarations
disclosure
sur
of
Règle
Arabic translations under Rule 73, 76.
Il y a des témoins pour lesquels la langue comprise par
Now,
l'accusé
in
est
some
déjà dans la
cases, the
déclaration et
witness,
donc
the language understood
c'est
by
déjà
the accused
accessible.
person is included in the original of the statement, so that information is accessible.
et des versions moins expurgées ont
There are
pu, le cas
less
échéant, être
redacted
communiquées.
versions that can be disclosed.
Il y a d'autres témoins
There
pour
are
lesquels la
other
traduction en arabe a
witnesses
été communiquée,
for whom the Arabic translation has been disclosed.
d'ores et déjà, comme P0524 ou P431,
For
P524 and P431. Et le reste est en cours, Madame.
and the rest is underway, Your Honor.
On fait aussi vite que possible.
We
On
are
a un
moving as
seul,
quickly
staff arabisant qui est capable
as we
d'appliquer
can,
et de
but
lever
we
les
only
autorisations
have
dans les,
one Arabic-speaking staff
documents,
member who can
et donc,
carry out the
évidemment, ça sera
redactions.
prêt
So
avant la
the work will be
deadline,
done before the
mais
deadline,
ça prend du temps, mais
but it
la
does take
défense va
time.
recevoir ça.
but the defense will receive the information.
Sachant que à ce stade, il y
You
a
must
toujours pour un
realize
certain
that
nombre
at this
de
particular
témoins
stage of the
uniquement
proceedings,
des
there are
draft
only
translations
draft
en arabe.
translations in Arabic for a
C'est
number
dû à
of
des
witnesses
questions de ressources,
owing
des questions
to
de finances.
resource and financial
Mais on
issues,
fait tout notre
but we are doing all we
pour,
can
obtenir les versions finales
to obtain final
dans
versions,
lesquelles on va devoir réappliquer
and
les expurgations
we will have to
qui doivent rester
make the
notamment
necessary redactions to those final
les
versions.
deux
B2
membres
redactions,
de la famille.
family members, possibly.
Je passe enfin aux
Finally,
demandes
I'll
de
move
participation
on
des victimes à double
to
statut.
the participation applications of dual status victims.
On a envoyé nos propositions
We have
d'expurgation sur
sent
les,
the
demandes
proposed
de participation des
redactions
victimes à
of
double
the
statut
participation
en toute fin de
applications
semaine dernière à
just at the end of last
représentants légaux
week
des victimes.
to the legal representatives of victims,
Ça concerne que 3
and it relates to 3
individus à ce
individuals at this
stade.
particular
Donc on attend le
juncture.
retour des,
So we are
des
waiting
représentants légaux.
for
C'est vrai que c'est
responses
très récent,
from
notre envoi,
the
mais on espère qu'on
LRVs.
pourra avoir une
It's
réponse
quite
bientôt et communiquer cela
recent,
à
but
la
we
défense
do
dans les meilleurs
hope to get answers from them soon, and then in turn we will be able to disclose to the defense as quickly as possible.
Donc au total,
In all,
il y a eu un gros effort
I would say that
de
great efforts have been
communication
made to disclose
d'identité
identities,
recommunication de
and we have
avec moins
redisclosed
et on
some
continue cet
documents
effort
with
pour
less
tenir la
redactions,
deadline
and
du
we are continuing our efforts to keep to the
10 mars,
deadline
prochain,
in
avec des
March
requêtes qui vont vous parvenir.
with a number of applications
pour
which will be
delayed-
coming to you for delayed disclosure.
Je vous remercie, Madame le juge.
Thank you, Your Honor.
Counsel, just before I turn the floor over to Ms. Taylor, I had a couple of questions just for clarification. I am concerned, of course, about the potential for 10 or 11 delayed disclosure applications, given the shortness of time in the proposed schedule. So I would like, if you're able to give an indication, are we talking short additional terms? Are we talking rolling disclosure applications? Should they be granted? this is a very tight time frame in terms of the defense ability to prepare for trial.
Ça serait jusqu'à une
Duterte.
période
It would be up to
de quelques mois avant leur
a
date
few months
effective
before the
de témoignage,
effective
pas
date
avant
of
la levée
testimony,
du procès.
not before the beginning of the trial.
Donc rolling disclosure.
So rolling disclosure.
Okay, thank you for that clarification. We'll take a look at the applications when they are received. And just secondly, on Rule 77, you said others were being reviewed. Any idea, can you give a rough amount of how many are under review? Just if you're able.
Mr. Duterte. Well, off the top of my head, no. But there's the Rule 42 ones, perhaps 7 or 10, 7 to 10. I'm speaking off the cuff. As for the others, these are standard things. It shouldn't lead to any delays.
Merci beaucoup.
The presiding judge, thank you very much.
Ms. Taylor. And I know you had a number of issues on disclosure, which obviously you can proceed to address.
Thank you very much, Your Honour. After hearing these submissions, we are still concerned that in terms of where we are very far from where we need to be. We are concerned by the sporadic and piecemeal nature of the disclosure we're receiving, and also by the fundamental mutations in the prosecution's case, in particular as concerns the disclosure of new witnesses and new statements. Now, we received the prosecution's provisional witness list, and it seems from the list that the prosecution is relying on 25 new witnesses that were not relied upon at the confirmation stage. Of these 25 new witnesses, 4 are entirely anonymous. For one of them, no evidence has been disclosed. For 12 of them, the prosecution either interviewed them for the first time after the confirmation hearing or disclosed evidence for the first time after the confirmation hearing. Now, putting aside disclosures of lesser redacted versions, since the confirmation of charges, the prosecution has disclosed 1,767 new incriminating items of evidence, totaling 7,268 pages of evidence. At the end of the confirmation stage, the number of items was approximately 9,000. So that means there's been an approximate 20% increase in the last couple of months alone. And we would like to express our concern that rather than preparing this case for trial based on the confirmed charges, the prosecution appears to be conducting fully fledged post-confirmation investigations. And in our respectful position, it's doing so in a manner that's not consistent with Article 54(1) of the statute. And if I may briefly go into private session to give a very specific example.
We could go into private session, please.
We are back in open session, Madam President.
Thank you. Please continue, Ms. Taylor.
Now, we know from open sources that various NGOs and entities have submitted complaints, reports and evidence to the prosecution concerning alleged crimes committed by armed groups in Timbuktu in 2012. But although we've requested this information repeatedly, we have yet to receive it. And that's a key issue as concerns the identification of perpetrators that goes directly to the charges. The prosecution has also adopted a piecemeal approach as concerns the disclosure of information concerning certain individuals. And if I can use that phrase without referring to the category of the individuals, I hope it's clear who I'm referring to. Now, we're getting information about these individuals in dribs and drabs, and it makes it impossible for us to finalise our analysis or to instruct any experts in relation to these individuals. For example, for particular individuals, we might get one medical report and not another one. But obviously we need the entire dossier to be able to instruct an expert. Now, as a practical solution in terms of moving forward, we're grateful that the prosecution's prioritising this, but we would ask that they transmit complete dossiers for each witness. Otherwise, we have to start and restart as concerns each witness, and we can't do effective analysis. In terms of exculpatory information, we've received no exculpatory items in the last 2 months. The last item we received was the public filing from the Trust Fund for Victims. The prosecution has also converted PEXO items into INCRIM as concerns P136. We've also not received lesser redacted versions of these PEXO items. As a result, and here I'm only talking PEXO, for P107, all we have is a 1-paragraph summary with no contact details. For TBT 001, we have a form with no name or contact details. For P005, we have an investigator's notes with 2 sentences, no names or contact details. So not only are we not receiving more exculpatory information, we still can't use the information that's been given to us. And we submit that Article 54 isn't fulfilled by simply giving us information in circumstances where we can't use it. Now, if we can't contact these individuals for reasons concerning protection or security, then there might be a need for counterbalancing measures. So we would suggest that at this stage, given the advanced nature of the proceedings, it's incumbent on the prosecution to contact these individuals to see if they will speak to the defence. If they won't speak to the defence, if there's no other mechanism, then we need to consider what remedy is available to compensate for the fact that we can't access or use these exculpatory sources of information. In addition to this issue, it would appear that we're not getting many PEXO items because the prosecution is interpreting its disclosure obligations in an overly narrow manner. And there's 2 key examples. One concerns information concerning those individuals. Now, Your Honour has already confirmed that certain categories of information is disclosable to the defence, that it falls under Rule 77 or Article 67(2). And if the prosecution has that information, it should disclose it. But the prosecution is not doing that. Instead, in lieu of giving us the actual materials, it's giving us investigators' notes. Now, many of these investigators' notes were drafted in 2019, after certain issues started to be litigated. So these aren't contemporaneous notes. They also lack key details. For example, for several of the notes, the note might say that the person will say X, but it won't tell us the date when they said that. It won't tell us the location where they said that, which is of crucial importance to our application. We need to know where they were at that point in time. We also have to have the interactions in the original. We need to know how the individuals express themselves, how they express their concerns, what particular language did they use, and what was the response of the prosecution when these concerns were raised. We need the evidence in its original. An investigator's note is not an adequate solution or an adequate compensation. It also has very little evidential value to us, particularly since the prosecution won't let us interview their investigators. So it's our position that given that we already have a ruling that this information falls under Rule 77, that it falls under Article 67.2, given that the Appeals Chamber in Tuganda confirmed that even if this information isn't under Rule 76, it's still disclosable if it contains information that falls under Rule 77 or Article 67.2. Given the Ongwen decision that's in our table of authorities, which also confirms that it's the original that needs to be disclosed and not a carbon copy, not an investigator's note, which lacks the detail of the original, we submit that it's incumbent on the prosecution to disclose its information. Since disclosure is the rule and non-disclosure the exception, it's not incumbent on us to relitigate matters we've already litigated. Given this ruling that it falls within the disclosure bracket, if the prosecution doesn't want to disclose it, it's incumbent on them to go to the single judge, not on us to try to, again, use our resources to obtain what we should already have. A second issue concerns the fact that in many instances when we write to the prosecution to ask for the disclosure of specific items, we will receive a response stating the prosecution has fulfilled its disclosure obligations or it's disclosed everything that's disclosable. Now, the problem with this response is that we don't have any clarity as to whether the requested information is indeed in the custody of the prosecution. And without that clarity, it's impossible for us to then seize the chamber. So we would propose that if the prosecution has the information, at the very least they should confirm that they have it, but are not disclosing it because they consider that it doesn't fall within their disclosure obligations. That helps to focus the inquiries. It means that we will only seize you as and when necessary, and we won't seize you with hypothetical inquiries because we're trying to parse the words of the prosecutor to work out what their responses mean. We think that we're fully prepared to engage in inter partes correspondence, but this correspondence needs to be clear and it needs to be geared towards facilitating the disclosure process and not delaying it unnecessarily. Thank you very much.
Thank you, Ms. Taylor. Mr. Tet, do you have any specific comments in response? But I would ask you to focus on issues where perhaps we can come to some kind of resolution rather than generalities, and particularly the last points that were just raised by counsel on the question of matters falling within the rulings or confirming you're having information. What the position of the prosecution is on those 2 points would be of particular interest, but I will hear your remarks. But let's focus on moving forward.
Mr. Dujut, I will endeavor to do so, but I did hear a great many generalities, and generalities are always lacking, well, not particularly informative and indeed at times misleading. But you see, a generality can always give a rather vague idea. Now, on the issue, I do have a lot of things to say about the points that my colleague raised, but in any event, I'll try to be brief. First of all, yes, we have received many emails from the defense with specific questions, and it is entirely inaccurate to say that we do not respond specifically. Over the last 2 or 3 weeks, I think perhaps 25 emails have been sent in response to queries from the defense.
sur la communication
Specific
de
queries, for
photographie,
example,
sur la
disclosure
communication
of a photograph,
documents
disclosure
concernant,
of documents
assistance
having to do
médicale,
with medical assistance,
passe.
and the list goes on.
Donc cela donne pas
So
une image exacte de
it
la
is
réalité
not
des relations entre
accurate.
épistolaires entre le
Well,
parquet et la défense.
I can say that this is not an accurate portrayal of the correspondence between prosecution and defense.
Alors, il y a des fois par ailleurs
At
où on affirme
times,
effectivement qu'on n'a pas ce type de document.
We do not have the kind of document
Plusieurs emails,
requested, and I have several emails
En tête,
in
où
mind
c'est le cas,
that show that this is the
notamment
case.
concernant,
For
des documents
example,
relatifs à l'arrestation
documents
de
having to do with the arrest of a
personne.
particular person.
Et puis, il y
And
a
then
des documents sur lesquels
there are
on est
documents
effectivement en train de faire la revue
that we are reviewing
et on a
currently,
indiqué que c'était en cours.
and we have told the defense that the
reviendra
review is
vers la
underway
défense
and that
avec
we
ces
will
documents.
revert to the defense with said documents.
Ce que je pense qu'il sera utile, c'est
And I
que
think
la
it would be
défense
useful if the
me
defense
renvoie les
could send me
demandes spécifiques
these
particulières
specific
pour lesquelles elle
requests
estime n'avoir pas de réponse.
for which they believe they have not received a
De toute
response
façon, on en a envoyé beaucoup, et
because
sur
they have
cette
sent
base,
many, and on the basis of that,
on reverra ça, mais je pense
we
qu'on a
will
répondu
review the list. But I
à
think we
l'essentiel
have
de leurs demandes.
answered most of the requests.
Sur la question
As for the issue of
des notes,
notes,
alors, parlons de façon simple et claire. La
let me be
défense
very
réfère
simple and
au
clear. The defense makes
security
reference to
assessment
security
and BSQ.
assessments and BSQ.
Au moins, qualifions les choses telles qu'elles sont.
Let's call a spade a spade.
Nous
We
extrayons
extract
l'information disclosable de ces
the
documents
disclosable information from the
qui
documents
contiennent par ailleurs de
that
nombreuses
contained
informations sur la
a great
sécurité
deal of
qui ne sont pas
information about security that cannot be disclosed,
disclosées. Et ces informations sont
and the
mises en note
information is compiled
et
into
communiquées à la
notes
défense.
and disclosed to the defense.
Et c'est conforme à la
And that is in
jurisprudence
keeping
d'un certain
with
nombre de chambres
the
de cette cour.
jurisprudence established by a number of chambers of this court.
Alors, si la défense veut challenger cette
And if
pratique,
the
je
defense
l'invite
wants
à
to
évoquer
challenge
saisir la
this
chambre
practice,
d'Alpha
I would
Link.
encourage them to
Développer cette question de manière technique.
submit a filing to the chamber, and we can have a more technical exploration of the matter. I think this was done a while ago, and I think it could have been done earlier on, not raised today.
Sur la question des
As
dates
for
dans
the
certaines
dates
notes d'enquêteurs,
found in a number of investigators' notes, I have told the defense that we are going to look at that and revert to them
avec de l'information,
with information,
c'est un
with
point qui a
additional
déjà été
information.
évoqué, sur lequel
So that point has already been raised,
de désaccord, on
and
va
we are
revisiter
not
cette
in
question
disagreement. We will revisit the matter, and we will look at the investigators' notes for which the defense believes they require more information, particularly dates.
Je me permets de
If you don't mind,
glisser rapidement
I
sur la
will
question des
just
documents
move very quickly to PEXO materials.
On a communiqué
We have disclosed a great many documents, no matter what category,
récemment in crime et rôle
both in CRIM and Rule 77.
et le cas échéant,
And,
lorsque nous avons
if
de
necessary,
l'information
when we
dans
have
ce document,
exoneratory
nous avons
information,
pointé dans le disclosure
we
memo.
have pointed out that information in the disclosure memo.
Donc, nous remplissons
So
effectivement
we
nos
have met our
obligations à
obligations
cet égard, et
in this
il n'y a
regard.
pas une boîte
And there is no
dans le bureau du procureur où il y a des
mysterious
documents PEXO qui ne
box
sont
with
pas communiqués.
PEXO documents that aren't being disclosed somewhere in the OTP.
On revoit ce qui est communicable et on le fait.
We
Mais parfois,
review what
la
is
nature d'un document est
disclosable
plus
and we
incriminatoire que
do
PEXO, et alors il part
so.
dans un dossier
But
incriminatoire.
sometimes the nature of the document is more incriminating than PEXO.
Donc, j'en termine là sur ces points. J'aurais
I
beaucoup d'autres choses à dire sur ce qui a
will
été
conclude
mentionné,
on
sur la
that.
question de
I
l'invitation,
have
etc.
a lot of
Très
other
bien, quand la
things
défense fait allusion.
to say regarding what the defense has alluded to, but I wanted to be concise as you requested, Your Honor, and just to provide information that can be very useful.
Thank you very much. And I do appreciate the concise response, because I think we can exchange on general points, and I think the position of both parties is clearly reflected on the record with the explanation of what has been disclosed, with the concerns raised by the defense. So I think the specifics are quite helpful. In general, I would like to, again, on this process, once again, I believe that a continuing good relationship between the parties, continue to discuss these issues when problems arise, as they always do in the context of disclosure, that you continue what is already evidently the practice of discussing those matters amongst yourselves and trying to resolve them. Obviously, though, if there are specific issues, then those should come to the chamber. Just let me comment on a few points, just in terms of giving some general directions. I understand the point you have raised, Ms. Taylor, that you obviously, when you make specific requests, you are hoping that you will receive responses to those. Those represent what you have prioritized as being important and urgent. I hear from the prosecution that they are endeavoring to respond to those specific requests. Obviously, I would encourage the prosecution to continue to prioritize those and to provide as much specifics as you can. If you have the information or you don't and you're able to reveal that, I think it's a reasonable request of the defense, so as specifically as you can. At the same time, I would encourage the defense to exercise caution as to the number of specific requests that are transmitted, appreciating you'll want to pursue your priorities, but of course, the more specific requests which get prioritized, it could also have an impact on the ability to deliver more holistic packages, for example, on disclosure, because of the resources that have to be diverted. So I think if both parties could exercise prioritization and consideration in these specific requests, hopefully they can be advanced in a constructive manner. Secondly, I do agree that that we're not talking about, on the issue you raised about the investigator's notes, we're not talking about a general practice for witness statements. We're talking about a very specific issues related to the security assessments, as far as I'm aware. And what I would encourage, this is an issue which it's not new, it's come up before, and if there are specific issues, specific instances, one of the practices that I think has been used in other cases is bring those before the chamber. And if there's a specific question about whether this information has been disclosed as fully as necessary, you can bring that to the chamber. The chamber can always review the original documents. So I would encourage you to try and reduce the issue to not generalities or not general practice. There is authority on this issue, but identify where you have specific problems, and if you need to, bring that to the attention of the chamber, but perhaps it can even be resolved inter partes. So I would encourage you, let's make this about specifics and not general. There are, as I say, there are authorities governing this in a more general instance. I think I'm going to leave it at that. I note that again, if there are any specific disclosure issues as you're going along, please bring them to my attention. But I would encourage, again, discussion, because this is obviously very important to the timeline of this trial. No one wants to see this trial delayed. So please bring any issues forward as you need to, but continue to dialogue on this, and hopefully it can be advanced. I note the defense's concerns. I would encourage the prosecution on the piecemeal issue. I know it's the problem of you want to give the information as soon as possible, but at the same time it may not be complete. If you can try, I think there are valid points made that if you get just a name and you don't have contacts, that makes the information less useful. So as holistic as possible, but I think everyone needs to understand that the rolling basis of disclosure sometimes presents those issues. So I hope that provides some guidance to the parties, and I would again encourage the continued, which I think is proceeding, noting the concerns of the defense, but at least I do see that we are making some progress in terms of disclosure, and hopefully that will continue. But don't hesitate to bring any issues forward should they arise. I'm going to leave that issue now and move very quickly, hopefully, through the remaining issues, which I don't think are as full, perhaps, as others have been. The next issue is the defense notice under Rules 79 and 80. Prosecution raised this issue. Yes, please, Council, proceed.
Thank you, Your Honor. I'll present my brief submission in approximately 10 minutes, if that's okay.
We could try and make it as brief as possible.
As much as I can, I will.
Thank you.
Your Honors, pursuant to Rules 79 and 80 of the Rules of Procedure and Evidence, the prosecution requests the Honorable Judge to set an appropriate timeline before the commencement of trial for the defense to notify the Chamber, the prosecution, and the participant of 1. Any intention to raise the existence of an alibi or any grounds for excluding criminal responsibility under Article 31 of the statute. 2. The specific crimes that these defenses cover. 3. The names of the witnesses and any other evidence upon which it intends to rely in support of these defenses. Further, the prosecution respectfully requests that it be allocated sufficient time after such notification in order to investigate these new defenses and be permitted to amend its list of evidence and witnesses accordingly, to add the necessary evidence and witnesses in response. Your Honor, I will address briefly the following 3 points. First, the appropriate time for such notice. Second, why the defense is in a position to give such notice, and giving such notice does not violate the accused's right to remain silent. In our respectful submission, this notice should be given prior to the commencement of trial. This is supported by the plain language of the rules and the case law of the court. Rule 80, Sub-Rule 1 specifically states that notice under Article 31(3) should be given, and I quote, sufficiently in advance of the commencement of the trial, end of quote. Rule 79, Sub-Rule 2, while it does not expressly use the term commencement of the trial, it nonetheless requires that notice under Article 31, Paragraph 1 is given, and I quote, sufficiently in advance to enable the prosecutor to prepare adequately and to respond, end of quote. Such phrase was consistently interpreted to mean in advance of the commencement of the trial. This interpretation is supported by the jurisprudence of Trial Chamber 1, Trial Chamber 7, and Trial Chamber 9. And for the record, reference is made to Trial Chamber 1's decision in Lubanga case, ICC 010401061235, corrigendum, Annex 1, Paragraph 29A and B. And Trial Chamber 7's decision in Bemba Ial case, ICC 010501131209, Paragraph 8, and Trial Chamber's 9th decision in the ongoing case, ICC 0204011540, Paragraph 8. For the sake of time, I will only refer briefly to this last paragraph in the ongoing decision, where the single judge found that, and I quote, notification that is sufficiently in advance to enable the prosecutor to prepare adequately and to respond implies notification prior to the commencement of trial. Indeed, the single judge notes that both Trial Chambers 1 and 7, which the defense in that case cites positively in relation to its submission as to the appropriate time of disclosure under Rule 79 of the rules, mandated disclosure in advance of the trial.
Counsel, perhaps if I could, I'm sorry, I apologize to interrupt you, but I believe the information you're providing is all actually quite useful. for the chamber. And this is a very important issue. I'm wondering, though, if it might not be more effective and save us time if this became the subject of a written filing from the prosecution, because that would also then allow the defense to provide a full response. I appreciate the depth of the information. As I say, it is actually quite useful for the chamber, but I'm wondering if that could also save us a bit of time, and if the prosecution would accept to do that. Certainly, all your preparation will go to good use because it could go into the written filing. So if that's acceptable.
Of course,
to the
Your Honor,
prosecution.
I'm in your capable hands. Thank you very much.
Thank you very much. And on that basis, Ms. Taylor, I would suggest that we simply leave any responses you may have to a written exchange.
Can I just ask one small thing which is related to this?
Yes, please.
It seems that a lot of these issues relate to the conduct of the proceedings, and we note that we do have this filing due next Friday, and we're wondering if it might make sense to collate the issues, but at the same time perhaps expand the page limit. Thank you.
Let's see what we can do in terms of the filing. I do appreciate those filings are coming, and if you do need an expansion to make sure everything's included, then I think we can simply accommodate that. So that might be an approach if the prosecution wants to follow that and bring everything together in one. It could be convenient, and I think we would be open to extension of page limit if necessary. So. With that, I think we can then move on to the next issue, which is an update on the agreed facts under Rule 69 of the rules. Oh, I see someone has risen from the prosecution team.
Oui, ma collègue Marie-Jeanne Sardachté.
Please, counsel, please proceed.
Yes.
Merci, Madame la Juge.
Thank you, Your Honor. I'll be very brief on this point. As indicated by Mr. Duterte during the last session, we approached the defense as early as October 2018 to come up with certain agreements, and after some failures we abandoned. But in the early part of the year, we made proposals on the civil status of Mr. Hassan, and also points on agreed facts, and also points in Timbuktu. Amongst those 14, these were conclusions of the Almadi judgment, which is res judicata today. After exchanges, we agreed on 4 agreements on the mainly on the civil status of Mr. Hassan. Recently, we sent the draft joint document to the defense last week. Yesterday, during an inter partes meeting, the defense told us that there were difficulties mentioned in the document relating to this agreement, but this was there just for the information of the chamber. It seems to be a problem for the chamber, so we decided to find a common solution to this point. I would like to raise a last point before giving the floor to my friend. During the last status conference, the defense said that they were possibly ready to agree on other facts, but after reading through the motion for amendment of charges or not, and after the disclosure of all incriminating evidence, we think that the defense can already take a decision on other points that may be agreed upon. To date, the majority of the evidence has been disclosed. They have received our provisional list of witnesses. They know the parameters of the case, and therefore can engage with us in matters of evidence. So we are waiting on the 14th of April the decision of the pretrial chamber on that amendment to discuss once again with defense. After that discussion, we do not exclude the possibility of filing a motion for you to take judicial notice of certain conclusions in the Almadi judgment for reasons of harmony and for reasons of the administration of justice.
Thank you very much, Council. Ms. Taylor, do you have any comments or anyone on the team who wishes to address this particular issue?
Merci, Madame la Juge. Très brièvement.
Thank you. Very briefly, relating to the four facts that we agreed, there is a technicality on the source of information. We said we do not accept the admissibility of validity of that source, but that is something that we will discuss further with the prosecutor. I don't think there are major difficulties there. Now, there are additional facts. We think under the present circumstances, it is still premature. We are still receiving a lot of redacted evidence constantly. We really have to review all that, and then possibly we can agree on other facts. For the time being, I think it is premature, but we remain in contact with the OTP on other facts. Lastly, they said they wanted to file a motion for a judicial notice, and then they can do that. Thank you.
Merci pour ça. Well, let me give an encouragement here. Everyone in this courtroom has an interest in this trial proceeding speedily, in particular, Mr. Al-Hassan. And one of the ways that we can achieve that and encourage that is through the use of agreed facts on matters which are simply not in dispute and do not go to the core issues that should be the subject of our time in the courtroom. So I would encourage, I think there are some facts at this stage which are not, it's not premature to be looking at them. We do have a previous decision. Yes, there can be an application for a judicial notice, but we do have a previous decision. When it comes to general facts, when it comes to context, when it comes to background, I would encourage the parties both to think broadly about agreed facts so that we can focus our time in the courtroom on issues that go to the core of the case. There is also a significant amount of documentary material in this case, including videos, and it would help advance the case if there could be an examination of potential agreed facts surrounding the technical aspects of those videos, surrounding identifications, surrounding dates, places, times. I would encourage not to think, I understand the defense's position that they need to be sure about the existence of proof, and I'm not for a moment suggesting you should be agreeing without being satisfied in any way about the nature of the fact. But there are, I think, a number of areas here that can be explored that will be to the advantage of everyone in advancing the case. So I'm simply encouraging a more aggressive approach, please, on agreed facts, and I hope by the next time we meet, perhaps there'll be more areas of agreement. I think that would be very encouraging, would be very helpful to the chamber as well in terms of being able to focus our time and resources. So there is my exhortation, which I hope will bear fruit in the next time we meet. That leaves us with, I believe, unless anyone else had any comments on that issue, I believe it leaves us with the question of the e-court protocol, I'm making a personal appeal that I hope the issue is not particularly technical, in which case you may lose the attention of the single judge. So I would encourage, if it is extremely technical, that the matter perhaps is best dealt with in writing, but if it is very general, then certainly you can proceed to make the representations.
C'est à ce point technique que moi-même je n'y comprends pas grand-chose.
It
Madame la
is
juge, que je laisse la
very
parole à
technical. I don't understand very much
présenté mis à
myself,
part
so I'll give the
sur
floor
des
to
points
Sarah
très précis.
Koki. Yeah.
Et après quoi, j'aurais peut-être une dernière
On
requête,
very
même deux requêtes à vous soumettre, qui est
specific
extrêmement courte.
points, and then after that I'll make 2 very brief submissions myself.
All right, that's quite a challenge, Your Honor. I will try not to be too technical, and I will just briefly discuss 2 series of changes that we are proposing, and should you, the defense, and the participants be agreeable, then we could implement those changes. It's just with the aim of making everyone's work easier and to maximize the utility and the coherency of the application of the e-court protocol. The first point is about the numbering regime. It's at paragraph 22, footnote 1 of page 5 of the annex to the decision ICC 0112-0118-31 that reads, and I quote, "The materials already registered by one party, participants, are re-registered if submitted by another party," unquote. We believe that such materials, if identical, should not be re-registered, but rather then parties and participants should use the existing ARN. This would help us avoid duplication of work and re-registering the same item multiple times over and over. Rather, such an item should be re-registered only if it has been altered and is therefore no longer identical. For example, if a witness made some annotation on a document. The second point is about the flexibility to make the system more user-friendly and precise. And I have 2 short sub-points here, but the core idea is to have more freedom or options for the parties to update the data they have provided. Flexibility should allow us to import the information that is not specified in the protocol. And of course, we agree that the protocol should define the mandatory metadata and the format in which the evidence should be provided. But this should not mean that we cannot provide additional information that we want the chamber, and especially the defense, to have access to. So the first sub-points concern some fields that are already in e-court, but not in the e-court protocol. And we simply suggest adding those fields. I'm referring here to 2 fields in particular. One is called basis of confidentiality, and the other is called pseudonym. Because e-court should mirror the e-court protocol. So we respectfully submit that this should be a given and highlight that this is already mentioned and in line with your decision 31 at paragraph 30 and paragraph 42. The second subpoint concerns fields that are neither in e-court nor in the e-court protocol, but that are highly relevant. This is specifically the case for the so-called, and sorry, it's technical terms, transaction data and path fields. Both fields are highly relevant when it comes to electronic files, such as the audios, the photographs, and the videos that you were previously mentioning, because they give you valuable information on the items, such as when the video was taken, if it was modified at any stage, if it was transferred, and when. So you need to know the creation date of the video, the date when it was modified or accessed, and this does not show yet in the fields in e-court. And this means that in practice, we could end up having to communicate all of this information for each piece of video via other means, such as emails, which are difficult to track, or they would have to be communicated in a technical or expert report, which when it comes to the metadata can be quite hard to read. It's just simply easier to have the data already available in front of your eyes whenever you open the actual video. Another example is 3D presentations. We have some 3D virtual reality presentations in this case, and they do not fall in any existing category or any format in eCourt. That means in practice that they are not properly categorized and they have to fall into another box. We suggest that, therefore, concretely to add a new image and data format for this type of evidence, for the 3D evidence. And the concrete suggestion is just to add it already in the protocol under B20G. The point with all this is that the eCourt protocol as it stands is slightly outdated. It was fine back in 2005. It had been tailor-made, but the suit no longer fits. And there is nothing more uncomfortable than wearing a suit that does not fit and that you have to wear for an extended period of time. So the format, therefore, needs to be adjusted to our needs here. And in a case like this one, where there is a high percentage of the prosecution evidence in such digital form, like the examples I mentioned, this is information that is obviously extremely useful to have firsthand for the chamber, for the defense, and the participants. So adding such fields will not only reflect the reality of what the evidence is in this case, but it also allows us immediately to provide all of the relevant information that we already have in our possession, but doesn't go through because the field has not been implemented. So to sum up, the second point, when something is not yet in the eCourt protocol, I would just say let's create ad hoc new fields, and that should not be an issue if it's highly relevant to the case, like the ones I mentioned. And even when it's not explicitly mentioned by the chamber, such as the case of this mysterious transaction data and path field and the 3D evidence I mentioned, then adding those would allow for significant information relevant to the parties to be easily presented, shared, searchable, and retrievable directly by one click. So in a nutshell, the right to have access to the record of the case by the registry is now limited by the format in which the evidence is made available to either party. And if that format is not in line with the type of evidence that forms the crux of the case, relevant information can be lost in the way. And no party here should be in an uncomfortable position where the information is not directly or easily accessible simply because a field has not been made available. That was all for the technical aspects.
Thank you very much, Council, and I do compliment you on making that quite understandable. Thank you very much. I have a proposal for the defense, which is I followed that submission, and much of it seemed quite sensible. Rather than asking for specific comments, of course you can make them if you have them today, I would suggest this may well be a matter that you could discuss together and come to an agreement unless there is a particular problem. And if there is, you could always revert to the chamber. But Ms. Taylor, if you have specific comments, but these do seem like reasonable proposals that would be beneficial to everyone.
Thank you very much. I feel like it's an issue we can resolve today, in fact. As concerns the first proposal, we have no objection. I would only wish to clarify that this only applies when it's exactly the same item from eCourt that's being used. So, for example, if you have the same item from different sources, it should be given a different number because the chain of custody will be different. But if it's someone using exactly the same item, then of course we completely support that proposal. For the second proposal, I did get lost in the details. Our only comment, I understand, is that we would not wish to lose the confidentiality field or the pseudonym field. But apart from that, we had absolutely no rejection, so I think we can resolve it unless there's comments from the registry or the LRV.
That's extremely helpful. I don't know if the registry has any comments on the issue. I think what we could do is, based on that agreement, I assume the protocol could be revised with those changes and additions, and then everyone would see it and could agree to it, and it could be sent to the chamber as an agreed amended protocol. If that way forward is acceptable to everyone. Perhaps the registry could in fact do that, consult with the parties and come forward with a revised document, if that's acceptable to everyone. That seems to be, I see a lot of nodding, and it's also the appointed hour, so I think our timing is impeccable. So unless there's any other further issues, Mr. Dutet?
Si vous le permettez, Madame la Juge, j'ai 2 points.
If you would allow, there are just a couple of quick points that I wanted to raise. The first point, well, we have to file a redacted public version of the filing today, 186, and I would ask for leave from the Chamber to do it after 4 o'clock. We've been quite busy yesterday and today, and as such, we haven't been able to give all our attention to it thus far. It's your decision, Rule 42 of last week.
I think that's fine.
Okay. Le deuxième point que j'ai,
It concerns the second point that I have, Your Honour, that concerns the way of proceeding with Rule 42. Now, the Chamber, Pretrial Chamber 8 said it wasn't have jurisdiction for that. You are seized of the matter yourself. And what we would like to do is to make a parallel with protection measures ordered by the Pretrial Chamber 1, and to have a system where we could perhaps automatically lift redactions of identity of such and such a witness, given precise conditions which we would put to you. That's to say that, in order to summarize the excellent notes prepared by my colleagues, within the framework of or where a witness agrees with the disclosure of his identity and it is considered that there's no security issue therein, then even under Rule 42, with your agreement, we could automatically lift propria motu the redactions. We will come back to you only for the witness under 42 who does not consent to the lifting of redactions on his identity, or where there is a witness who we are unable to contact, or when security issues are such that we do need to go through a decision from you. That will make it possible for us to accelerate the disclosure process and to come back to you only when it's necessary. And to have your general agreement would help respond to revision by your chamber, as envisaged under Rule 42.1.
I think that sounds like a very sensible approach on this issue. I think what might be helpful is simply to confirm the process by way of an email communication to the chamber, and then we can respond, and so that we'll have a record and it'll be clear on the record. But in principle, I think what you're proposing, particularly where there is the consent of the witness, but if you could just set it out and we can respond accordingly, that I think that just helps with having a clear record of what was decided.
Thank you, Your Honour. And I'll just take this opportunity to raise the idea that the Arabic version of the prosecutor's application for corrections was filed yesterday by the registry, but we had a notification thereof only today. Thank you for that, says the presiding judge.
Issues for today. So I would like to thank you all for your coming and your cooperation and your input. I would also like to thank, of course, as always, our interpreters for their fine job, the court reporters and our security officers for their assistance today, and I wish you all a very good afternoon. The session is adjourned.
All rise. We will be